Okay, so Brexit has happened, and I guess it'd be good to have a sort of high-level view to start with, at least, as to what you see as any impact, whether those be positive, I guess, or negative, in terms of the data, anything specific to the data industry, and then we can maybe drill down into one or two areas.
Yeah, sure. I mean, I think in terms of growth and things like that, I think the UK data construction market's it was very buoyant in 2019 and 2020, and bearing in mind the referendum was in 2016, which feels like an age ago now. I think COVID-19 has certainly affected the speed of some of the 2020 construction projects, but fundamentally, I think if you kind of discount COVID out of it, I think fundamentally, I think there remains a desire to build data centers in the UK. Just anecdotally, we've been extremely busy. To be fair, quite a lot of the work that we're doing at the moment is outside of the UK, but there is clearly a lot of talk about expansion within the UK. I think we probably see quite a number of the data center operators responding to what they perceive their customer base requires. So we might see a little bit of I don't know, to use an expression, we might see a bit of right sizing going on. So you might see some data center companies targeting more EU countries rather than the UK at the moment, just because they feel as though that's where their customer base is headed, and that's where their customers have decided that they should locate their data. But I don't think any kind of right sizing process, any kind of temporary right sizing process could cloud our judgment on the data center market fundamentals. I think once all that's settled down, the UK data center market remains very strong. I suppose in terms of Brexit itself, I will call the trade and cooperation agreement, I'll call it the Christmas Eve Brexit agreement for the purposes of this, but that left a few questions unanswered with regard to the UK banking and finance service sector. So we've still got a little bit we still need to find out where they're going. And obviously that sector is a large user of data center telecommunications. But given the importance of that sector to the UK economy, I think we can be pretty confident that the government will, push hard to kind of keep that keep that whole, really. A number of things have happened this year. COVID-19 has been an accelerant for most businesses in the UK, particularly service sector businesses, where people have been working virtually online and have been working from home. So I think we probably we'll see a bit of a return to the traditional office-based ways of working, but I don't really see a reversal of that trend, because once we as a business, we're all working virtually, and once you've given that kind of flexibility to people, you can't really take it away from them. So as a consequence, I think businesses' IT needs have become more complex. So that's generally speaking, when the IT needs become more complex, that's a good reason for outsourcing it to experts. So I think, generally speaking, I think notwithstanding Brexit, I think all of the drivers for continued growth in the UK data center sector are there. I think, in addition to all of that, we've got edge data center use cases emerging, lots of technological innovation going on, and the UK has traditionally been very strong in that kind of innovation. So I think that will similarly create a healthy demand for data centers. So what do I think? I think will Brexit have some long-lasting negative effects? Yeah, it might do. Will it create some short-term upheaval? Yes, it will, and I think we'll come and we'll talk about that later on in this broadcast. But I do think that the UK market is in a good shape.
Okay, and in terms of the, I mean, you say obviously, construction seems to be, or the demand for that data center still seems to be there. So building data centers, do you see any issues around the construction sort of industry sector? Again, we're focusing on the Brexit. So in terms of the supply chain, I know again with COVID, it might be a bit confusing because there's been issues potentially with that. So maybe on the supply chain side, and also maybe on the skill side with freedom of movement or lack of, where people, who's allowed to come how robust, I suppose, is the construction industry within the UK when it comes to the data centre?
Yeah, I think Brexit has presented a number of issues for the construction industry, and you're right, some of those have been masked by COVID. I think the Christmas Eve agreement, that was pretty helpful in the sense that it established that there wouldn't be any financial tariffs and import duties on goods that are routinely used in the UK construction industry, and particularly for the kind of heavy M&E equipment that's used in data centers. A lot of that is imported from the European Union, from Germany and what have you. So we know that there's a commitment from that Christmas Eve agreement. We know that there's a commitment that there won't be financial tariffs, but there's been a lot of disruption, I think, on what's called non-tariff barriers. So that's all the paperwork that has to be completed in order to import goods. Now, that Christmas Eve agreement contains a commitment on behalf of both the UK and the EU to minimise those non-tariff barriers, but we're quite a long way off that yet. And the truth is that quite a lot of the detail on how that's going to work is not there. I think the agreement sets out a framework, and there's a kind of, it lists out a myriad of number of councils and committees and working groups and what have you that are going to work on a lot of this detail in the future, but we don't really have a lot of that information in place yet. So I think Brexit will have an impact on the importing of goods that would traditionally be used in the construction industry. I mean, right now we're seeing some anecdotal evidence coming through of things that contractors are trying to import being held up at borders, and I think that will continue for a short period of time at least. I think I was looking at there's a Federation of Master Builders. They've done quite a lot of work on this, and they've done a survey back end of last year, and they were saying that 87% of builders had faced cost rises as a consequence of supply chain disruption. So on the one hand, we say there's no additional tariffs and duties on goods being imported, so there's no direct cost, but this 87% of builders who are reporting supply chain disruption and additional costs as a result of that, well, that's the non-tariff barriers. And so whilst they might not be tariffs, they're certainly having a financial impact on people. But the other thing that's quite worrying, I find as a statistic, is that, again, the Federation of Master Builders, they're saying that 40% of SMEs involved in the construction industry are just not ready. They haven't really worked out how they're going to service the UK market from Europe or vice versa. That's a really high statistic, I think, 40%. And if you think that within the construction industry, the SMEs tend to be right at they're right at the bottom of the supply chain, but they can have a really significant impact. So I think in terms of goods and the importing of goods and materials from the EU, I think Brexit could have a significant issue, particularly in the short term. There is this commitment to kind of iron out those issues, but we might have a bit of a rocky road for a while. In terms of personnel, the data center sector particularly has complained of has quite rightly complained of a skills shortage for a number of years now. And I can't see how Brexit's going to help that, to be honest. If you just take the construction industry itself, so the Office of National Statistics is saying that across the UK, generally 10% of workers in the construction industry are EU nationals, and if you take London, that figure rises to 33%. So that's a significant effect. CITB have been warning about recruitment shortages, and they've seen a 40% decrease in the number of EU people coming to the UK to get to seek construction work. So those all point to the fact that, whether you believe the statistics or not, those all point to the fact that there is a significant issue, and there's likely to be a skills shortage within the UK construction industry, certainly in the short term. It's just not going to be possible to upskill UK workers to cover those kind of jobs in the short term. So I think Brexit does have that consequence for skills shortages. Your listeners might want to know very quick rundown on what the kind of new rules are, and happy to do that. So for kind of permanent staff, if EU workers had been in the UK before the 31st of December 2020, then they need to apply under the EU settlement scheme, and they must do that by the 30th of June this year. So there's clearly an urgency to doing that. And for workers that are coming into the UK from the EU after the 31st of December 2020, well, they have to apply under the new UK immigration rules. So that involves them demonstrating that they're skilled, they fall into the category of skilled worker. And that's quite a broad list. So people like bricklayers and carpenters would fall into that. But people like general labourers and some kind of plant operators, drivers of diggers and that kind of thing probably wouldn't. But they have to apply and they have to go through the immigration rules. They'd have to be sponsored by the business that's employing them, and they have to have a job offer that has a salary above the minimum. The minimum, I think, is about 25,000, something like that. So that's, for the construction industry, that's a fairly high salary. So I think there are going to be some issues there. One of the sad things I thought that came out of the Christmas Eve agreement was that the UK was no longer going to be part of the Erasmus scheme. So for new graduates coming through, which you're looking long term to the industry, for new graduates coming through, that's a shame. I think I understand we're going to have some other scheme, a Turing scheme or something like that, but I think it's a bit sad, really. So yeah.
And just in terms of that, of the existing overseas or European folk, and obviously they're obliged to apply for residence, demonstrate, whatever. But in terms of the employer, does the employer have any responsibility whatsoever? I'm just thinking, if you've got a bunch of people from various European countries working for you, do you have any obligation after the June deadline to check your employees are here legitimately, or is that their problem and you don't have to worry about it?
No, you do have to worry about it. There is the usual kind of right to work checks that one has to carry out if you're employing anybody. So yes, the businesses, they do have to be concerned that their employees are appropriately in the United Kingdom and have the right to be here.
Okay, so we've talked about construction in terms of the supply chain and the skills potential issues with those. Are there any other construction related issues that folks need to be aware of?
Yeah, sure. So there are, I think the biggest one that people are talking about now is to do with product standards and certifications, particularly around kind of equipment. So I don't know, UPSs or generators or even particularly smaller electrical mechanical equipment. So people will be used to seeing the CE mark on products, consumer products as well, but particularly on products that are incorporated within construction projects. So we've got we have some transitional provisions in relation to product standards and certifications. So at the moment, we've largely transposed and mirrored the EU requirements into UK law, but over time, the CE mark, which is a European certification mark, that's going to be replaced by a UK marking system, which we think will be called the UKCA, United Kingdom Conformity Assessed. So it will be a UKCA mark instead. And we think that will relatively closely align to the CE marking scheme, but at the moment we just don't know. It's one of those things that I talked about, some of the various fora that the Christmas Eve agreement sets up. Well, this is one of the things that that those fora will look at, I have no doubt. So we think it's going to be closely aligned to the CE marking system, but we really just don't know at the moment. So, and probably over time, there's going to be some divergence between what the EU requires and what the UK requires. And if that is the case, then it's going to be annoying for manufacturers, because it means they're going to have to potentially make separate products for the UK and the EU markets. which is obviously costly, and having to market two different products and to stock two different products, all of that kind of stuff. So that's just something to watch, and does certainly relate to construction.
And so is there a time frame on that? So is there a point at which a UK company can no longer put a CE mark or on their kit, or vice, how that resolves itself?
There is, and I think it is next year actually sometime. I can't remember off the top of my head. I think it's 2022 sometime.
Sure.
But I think CE marks are recognised until 2022. Yeah.
Okay. And moving on, I mean, if we're looking at another bit of the data center, clearly sort of telecoms and connectivity is a massive part. And I know that sort of headline thing is the mobile phone roaming charge may or may not, we may be charged more again when we're going around Europe. Still to be decided, I guess. But in terms of the infrastructure to data centers, clearly it knows no boundaries. Are there any issues around whether it's operators, are they all international and they're all okay? Just give us some indication of whether there are any complications to do with connectivity between the UK and Europe now, or it's not an issue.
Yeah, there's certainly some changes, and I mean, it's not just connectivity either. It's also the users for some of the end users of data center services. So not just telecommunications, but I mean, you've mentioned things like we're no longer going to have capped mobile phone charges. So that'll be a very visible thing for some people. Although what I'm seeing is that most of the network operators in the UK seem to be standing by what they had before, but maybe that will change over time. We have data privacy and data protection, which is the kind of elephant in the room, but maybe we talk about that separately. In terms of telecommunications itself, well, we're no longer part of the single market for the purposes of the telecoms regulatory framework. But a lot of the European frameworks, so particularly the European Electronic Communications Code, that's been transposed into UK law for the time being, at least. What's happened with an awful lot of the EU regulatory laws is that they have been transposed into UK law, but that the UK now has a kind of right to diverge from them. So over time, we anticipate that there might be that divergence, and so obviously people who are affected by it need to keep an eye on how that might pan out. So telecommunications regulatory framework is broadly similar at the moment. Things like the European e-commerce directive, which was a really important piece of legislation affecting many online service providers who were providing services throughout the EU and the wider EEA, in fact. That no longer applies. So operators who are providing those kinds of services, online services, they'll need to consider issues like how much information they provide to customers on their websites, how they advertise their services, how they enter into contracts, kind of click to accept type arrangements, all of that kind of stuff. So that actually has quite broad consequences, I think. And then for certain particular industries like broadcasters and video on demand services, which are based in the UK, they will have to, depending on, in certain countries within the EU, they may have to apply for licenses in order to be able to broadcast there. So there's changes that affect those kinds of industries. One of the areas that will be particularly relevant to data center operators will be some of the changes around cybersecurity. So we had, many of the data center operators will be used to dealing with the National Cybersecurity Centre, the NCSC, which is part of GCHQ. So they'll be used to dealing with that, and they'll know about things like the network and infrastructure systems regulations, the NIS regulations. And much of the UK's law related to cybersecurity came out of the EU. That's where a lot of it has come from, and it encompasses things like minimum standards and incident reporting, cooperation and investigatory powers of the authorities. So what can the police come in and require you to disclose, all of that kind of stuff. So in terms of practical effects for data center providers, the effect of Brexit for those data center operators that would fall under the NIS regulations, it means that if they're based in the UK but they're offering services in the EU, then they need to nominate a representative in an EU member state who is kind of the licensed representative, if you like, and that person would have to be licensed by whichever member state's competent authority. So, for example, in the UK, the competent authority is the Information Commissioner's Office, the same people who deal with data protection. And similarly, for EU operators who want to work in the UK, they would have to appoint a representative in country in the UK who is notified to the ICO, and that individual would then have the primary dealings with the National Cyber Security Centre about cybercrime and reporting of incidents and all of that kind of stuff. So for anybody who's doing network operations or any data centre provider, those are potentially impactful things. They might need to get their heads around a different regulatory regime and report into a different authority.
And so just on that, but did you say they only had to, so if you're UK based but offering service in Europe, you have to have one competent individual for the whole of the EU, or do you have to have one person per member country?
You have to have one within a member country. Yeah, within an EU member state or an EEA member state. Yeah. So that then for the, so basically you nominate a home state within the EU that will be your regulatory state almost, and as long as you've got one of them, then that's fine.
And I think you mentioned the elephant in the room, which Brexit or not has exercised our minds greatly. So without going over too much ground, but obviously the GDPR arrived, I think, was it 2 years ago, and caused a lot of, how should we put it, consternation. The UK's Data Protection Act, I believe, was superseded by that. And then obviously the EU-US Privacy Shield, the EU, I think, sort of indicated that they had rejected that last year. So chaos might be the word to describe it. And then you throw Brexit into it. Do you have any thoughts, advice? Can you help people understand? And I know I'm going on a bit, but just one final thing. I know even under GDPR, I think there were a lot of people offering services suggesting things about, where data could or couldn't be held that maybe weren't, legally accurate. But if it meant they could scare people into, keeping data in a certain country or whatever, it was obviously good for their business. So I suppose, are you able to sort of summarize the landscape at this moment in time? Is that possible even?
I can try for sure. I think you're right. I think I reflect on all of the stuff that happened around Y2K. If you remember when we were heading into the year 2000, and there were lots of people selling lots of services about making sure that your computer systems weren't all going to fall over because they only recognised the 2-figure date and they're going to think it was 1900. All of that kind of stuff. There was a lot of scaremongering around that, and some of it, of course, not without merit, but there was an awful lot of, I think quite a lot of people made quite a lot of money out of that, to be honest. Not just lawyers, but other people as well. So yes, data protection. Well, I'm afraid that the Christmas Eve agreement kind of kicked the can down the road a little bit on this one, and that I think was probably expected, but it was disappointing all the same. So let's just get a bit of context here. So one of the scaremongering tactics that I often see. So data protection rules apply in relation to personal data. So it's data about individuals, recognizable, identifiable individuals. So it's not all data, and I think it is quite important to put that gloss over, what I'm about to say, because you do see kind of people saying Armageddon has arrived and no data can move anywhere. It's not to underplay it, because an awful lot of data is personal data, but I think it is important just to have that thought in the back of people's minds. So in terms of Brexit and the legal landscape, the EU GDPR actually was essentially adopted into UK law. So when we entered into the EU Withdrawal Act back in 2018, with the Brexit Act, that basically transposed the EU GDPR into UK domestic law, and then it supplemented it with the Data Protection Act 2018. So we now have an EU GDPR which applies to member states of the European Union and in large part to the EEA countries as well, and then we have a UK GDPR. And the objective really with the UK GDPR was to recreate as much as possible the kind of familiar concepts that people, particularly end users, would know and be familiar with from the EU legislation. So we don't go back to just the old Data Protection Act as it was. We have a mechanism that exists which is very similar to the EU GDPR. It has some different terminology. It has different regulatory bodies. Some of the things where it talks about euros have been converted into pounds, that kind of thing. But fundamentally, the concepts are familiar. Where it gets tricky is about how data transfers from one regime to another regime. So from the EU to the UK and vice versa. That's the tricky bit, because although these regimes are pretty similar, they are legally different regimes. They're different mechanisms. So how does personal data transfer from one to the other? So the Christmas Eve agreement provides for some interim provisions, and this is why I say it's kicked the can down the road a little bit. So, and everybody's talking about this being a 6-month transition period. Now, actually, technically, it's a 4-month transition period. So, and then it can be extended for a further 2 months if either the EU or the UK asks for it. But it may be that everything suddenly drops into place, in which case these transitional provisions will end on the 30th of April 2021, and everybody will have to adhere to whatever it is that has dropped into place. So that's just an important thing to note, because everybody just seems to be talking about 6 months, but actually it's 4 + 2. So as a consequence of these interim provisions being imposed, for the purposes of data protection, the UK is effectively deemed to be still part of the EU. Okay, so the normal EU rules apply related to transfer of data between EU member states now apply to transfer of data between the EU and the UK. So those normal EU regulations around transfer of data to what's called a third country don't currently apply to the UK during this transitional period. So you don't have to worry about standard contractual clauses or binding corporate rules or anything like that, which your listeners might have heard about. You don't need to worry about that. We don't need to worry about implementing that right now, because we're still within this transitional period. But that's not going to be a long-term solution. And what we're really waiting for is what's called an adequacy decision. And what an adequacy decision will give us is it will basically say that the European Union deems the UK's data protection provisions to be adequate, and therefore people moving data from the EU to the UK don't need to undergo any further special protection and safeguard measures. But we haven't had that adequacy decision yet. So here's the interesting thing. The UK has already granted adequacy status to the EU. So regardless of the interim provisions that are in place via the Christmas Eve agreement, data can be exported from the UK to the EU without you having to have standard contractual clauses or binding corporate rules. And that provision is, to all intents and purposes, that provision is now permanent. That is the position. But the same does not apply in reverse. So at the moment, the EU Commission has not granted an adequacy decision in favour of the United Kingdom. So they have not yet said, we think the United Kingdom's mechanisms for data protection are adequate so that EU personal data can be exported to the UK. We're still waiting for that decision to be made. As I say, the interim provisions that are in place apply whilst we're waiting for that decision to be made. Hopefully that decision will be made and it will be a favourable decision before the 30th of April or at the very latest the 30th of June. Once that adequacy decision is in place, if assuming it is, then that will allow EU member states to transfer personal data to the UK without having to have standard contractual clauses or binding corporate rules. There is a bit of a question mark about whether we're going to get that adequacy decision from the EU Commission at the moment. So I'm not a betting man really, but I'll give a bit of a view on where I think that's going to pan out. So the Christmas Eve agreement makes some warm noises, shall we say, that an adequacy decision will be granted in favour of the United Kingdom. It is true, and quite a lot of commentators have mentioned this, that the EU has previously expressed some concerns about things like the pretty wide investigatory powers that the police have in the UK over personal data. So all of the stuff that used to be called the Snoopers Charter, and your listeners might be familiar with that terminology. So the EU did have some concerns about that, and there was also some concerns around the intelligence relationship that we have with the United States and other countries, the kind of Five Eyes relationship that we have. Because in the United States, those investigatory authorities have very sweeping powers. The NSA and the FBI have very sweeping investigatory powers. And then there was also some comments that were kind of made by the European Court of Justice. There was a case in last summer called Schrems. It was actually Schrems 2, which some of your listeners might be familiar with, and that was actually related to Facebook data. And there was some kind of noises made in that case, in that judgment, which some commentators took as an indicator that the European Union might not give an adequacy decision in favour of the United Kingdom, primarily because they were concerned about the closeness of the relationship with the United States. So the Schrems 2 case was the case that basically canned the privacy shield arrangements, which had been in place between the European Union and the United States up until then. So there's lots of commentators are saying there's a number of reasons why the EU might not give an adequacy decision in favour of the UK, but that would seem a little perverse to me, if I'm really honest.
Sorry, can I just, because if I understood it correctly at the start of this, you indicated that we'd more or less adopted wholesale the GDPR across into UK law. So if we have, theoretically, we're not diverging, therefore there's no logical reason. Clearly the politics may, get in it, but the EU doesn't appear to have, they appear to be abiding by the rules, not going out their way. But so if we carry on and say we're going to abide by GDPR, there's no obvious reason. But if we do start, as you say, diverging and butting up to the Americans or Facebook or whatever it happens to be, then they'd have legitimate reasons for concern. Yeah,
I think that's kind of why I think it would be perverse to decide otherwise. I mean, it's a bit like saying, before Brexit, you adopted these rules, which were the same rules as we've adopted, but now we think, and whereas we thought they were adequate before, now we think they're not, even though nothing significant has changed, because you're still adopting, you're still working to the same regime. So it would feel a little bit odd if the EU didn't give an adequacy decision. It's not to say they won't. They may well do. And I think our advice at the moment to clients is get ready, just in case. Don't do it. Don't implement things that are going to be really expensive to implement or really difficult to kind of reverse out of. But get ready just in case, because we don't know, and we don't know what the attitude of people like the ICO will be once we do know, how quickly they will say, well, we're going to enforce this.
I was going to say, would there, I mean, you've indicated obviously there's the end of April, end of June, these sort of two periods, by the end of which a decision will have been made. But once that decision is made, is it again reasonable to assume that there will be a grace period? Because if you've got vast amounts of data that potentially has to get moved, across various geographical areas, that's not something, even with great connectivity, large data centers, etc., you can't do that overnight. So potentially would be you've got 3 months, you've got 6 months to sort yourselves out. No?
Yeah, well, there's nothing in the Christmas Eve agreement to provide for a further transitional period. So there's nothing to say that it has to be that way. But having said that, just purely from their own capacity perspective, the ICO is going to be very busy, right? So their ability to actually look at anything but the most flagrant breaches is going to be problematic for them. They're going to have their own capacity problems, one would imagine. That's not going to give comfort to lots of people, because you don't want to be in technical breach, but just not get caught for it. But so I think we need to be ready to respond to that fairly quickly. And the way we would respond to it, one expects, is if there is no adequacy decision from the EU Commission in favour of the UK, then the UK would be considered to be a third country for the purposes of the EU GDPR. And in those circumstances, you have to be treated. The UK would be treated the same as the US, for example. So that would require standard contractual clauses, which the form of those is mandated by the EU GDPR, or binding corporate rules. Those kinds of things would have to be put in place to enable data transfer from the EU to the UK. I would hope. So another thing happened in Schrems too, which was in that case, which was that the ECJ suggested that just adopting standard contractual clauses might not be enough, and that you would have to look at each individual incidence of data transfer to work out whether something more should be done to ensure the adequacy of that, the adequate protection of that data. So we'd hope, if we don't get an adequacy decision in favour of the United Kingdom, then one would hope we'll at least get a bit more guidance upon how that's going to operate in the future. So I think for now, I wouldn't say it's chaos. I think it's a bit of the can has been kicked down the road. It's a bit of business as usual still, but with a mind to something that could happen in April, June time, and therefore people need to start gearing up for that and thinking about that, and trying to put into place provisions to the extent they can do that without expending a huge amount of money doing it. That's really the advice we're giving. For those clients who have got significant data transfer, complicated data transfer issues, so that's not the advice I'd be giving to somebody like Facebook, because clearly they've got a huge volume of data that they've got to deal with, and it's going to be extremely tricky for them to deal with it. But for most SMEs and people like that, then I think it's about getting prepared and getting ready, but not doing anything that is significantly expensive at the moment, in the hope that we will get an adequacy decision in due course.
And I was going to say, just on a wider issue, not maybe this whole data privacy compliance thing. I mentioned the social media giants, stuff like that. Do you have any views? Because clearly there are, and I dare say with COVID, vaccines and research and stuff, there are major advantages potentially to accessing data for governmental reasons, great ones, positive benefits to most of us, but clearly people are worried about. Do you have any thoughts as to where that balance? I mean, is there even international consensus over that? Or again, I know it's a big question, and we could perhaps have another debate, but just any general thoughts as to the balance between an individual's right to remain off-grid, anonymous, as opposed to the overall benefits to society of being able to find out a lot of things about us that may benefit, the whole population. That
Yeah.
kind of
To be really honest with you, on a truly global basis, I think that is an incredibly cultural thing. An incredibly cultural thing. So if you ask people in certain states, particularly countries that have had a totalitarian government in the past, their citizens are extremely nervous about handing government any kind of data whatsoever. And then other countries have a far more lenient view in relation to that. If you ask somebody in Russia about their view on it, it's going to be quite different to somebody in the UK, similarly China. So there isn't really a huge consensus on it, is the truth, internationally. And I'm not sure there ever will be, if I'm really honest, because it is a hugely cultural and historic thing. Where I think there are great advances to be made is basically on the anonymization of data. So if you can look at a class of data and not be able to identify the actual individual, but you can see that there are, 1 million people in London who contracted COVID-19, and you can trace where that, where they were, but you don't know who they are, then that kind of information I think is very valuable, and I agree with you. So I suspect that's where the effort will be placed, is on how one can really accurately anonymize data.
Well, I guess that comes back to trust a bit, doesn't it? Because if you're given your data, even any survey, they might tell you they're not going to do this, that, and the other, but they tend to require a certain amount of information about you just to make that data useful. Whether people trust that they will be anonymized or not, I guess, is another.
Well, the NHS tracking, the mobile phone tracking tool is a really good case in point, isn't it? So we had lots of discussions about where that data would be collected and what data would be uploaded, how much data was actually collected on the phone and held locally, and how much of it would be uploaded to a central system. So there was lots of discussion about the Apple and Android approach to it versus the original version that the UK government looked at, and which was more centralized data. And they said, well, if we have more centralized data, we'll be able to do more with it. We'll be able to spot more trends with it and what have you. But I think partly because of some technical issues with Apple, they couldn't do that in the end, and they realized that it wasn't possible to do that. But I think that did open up some very interesting questions around people's attitudes on anonymous data and what data is being provided. Had that question been posed in something other than a global pandemic, I suspect we might have had a more cautious approach to it. But yeah.
Okay, I mean, we covered a great amount of ground, some fascinating stuff. Are there any final thoughts? As we started with the sort of overall impact of Brexit. I mean, are you a glass half full person that it'll all sort of come out in the wash, and in 12 months' time we'll wonder why we ever sweated about all the, whether we believed in it or not, the technicalities, all the potential banana skins really weren't that important? Or do you think there are significant sort of long-term issues that need to be addressed? Some of them might be beneficial and some detrimental.
I think with everything there's going to be winners and losers. That's always the way, and that's always problematic, of course. I think in the short term there's an awful lot of work to do. There's a lot of upheaval. There's a lot of getting used to new systems, getting used to new processes, new forms to fill in, all of that kind of stuff. There's lots of that going on. I think for businesses that haven't yet got their head around what Brexit means, and there do seem to be an awful lot of them that haven't, then they need to be doing that very urgently, particularly around the data protection side of things that we talked about. Long term, I think we can only hope. I mean, if you look at the Christmas Eve agreement, it creates a framework really there's lots of words in there which I'm not suggesting anybody goes and reads it. It's about 1,200 pages long, I think. But
God forbid our politicians even know. But
yeah, well, I did read about 3/4 of it, and then even I gave up. But yeah, but I think it creates a framework. There's lots of words in there which talk about the member states and the United Kingdom will work together to achieve the following objective. They'll put in place a mechanism to achieve the following objectives and that kind of thing. So it highlights to me that there is an awful lot of work still to be done, a lot of the details still to be done. And much of what we have got at the moment is a transposing of EU law into UK law to give us a temporary measure, really. That will change over time. One of the things that the agreement sets up is a real framework for the establishment of lots of councils and committees and working groups and all sorts of things. So I think it's going to be really important that the UK data center sector, the telecom sector, and all of the digital economy sectors are properly represented in those various fora, and that their interests are properly represented, because we've seen that happen before, particularly in data centers where, as a lawyer working in the data center sector, we've had to look at an awful lot of legislation which has been drafted without the data center sector in mind, and they've kind of accidentally got caught by it. So I remember lots of the kind of legislation around power generation and things like that, which really wasn't intended to capture data centers at all, but ended up doing so. So I think it's really important that the interests of the industry are represented at those various fora, because it's there where the devil is in the detail is going to be. That's going to be created. It'll be in those organisations.
And so on that point, those various fora you've alluded to, is that something that will be sort of industry to industry, or is it all depend on government sort of recognising the importance and then getting the relevant folks involved? So if you run a data centre in London, will somebody invite you join this, or is it, as I say, down to the government to recognise the importance for each industry sector, including the data centre, to be involved in the the discussions?
Good question, and I don't know the answer to that. It's not particularly clear, although I suspect that a number of the big organisations, so people like Tech UK, there'll be an awful lot of conversation and lobbying going on there. I hope there is, anyway, to make sure that the interests of the industry are represented. But yeah, I think we need to the industry needs to make its voice heard. Is what is basically my parting comment, really.
Okay, well, absolutely brilliant to talk to you. So Ed,
thank you.
Thanks very much indeed. Thanks.
Very good to talk to you as well. Thanks.